Okay, in this section, we're looking at the Nuremberg and Tokyo trials, because it's important to look at these trials to see this as a stage of development of international criminal law. So while there may have been elements of international criminal law before, and there may have been some attempts to use them in a court, this is the first time that at almost like at an international level, we see these laws being implemented. And so what happens in Nuremberg, and this is after World War II and all the atrocities that had been occurred there with, say, the Holocaust of the Jews and the unprovoked attacks against countries, that the winning side in the war, which was the Americans, the English, and the French, and the Soviets, wanted to put on a trial to try the leading figures of the German Nazi Party, and also for the Americans, leading figures of the Japanese military as well. But there's a whole range of things which have to be kind of put together. You know, first is they've got this desire to have this trial, and that's because they didn't want to. They thought this is important to stop a war like this happening again. After World War I, there was a kind of a missed opportunity to have a trial. So there were some trials, or I think there was a trial that occurred, but it's largely forgotten and was very ineffective. And they recognised that they couldn't try any leading figures. But also, it was a bit more difficult because World War I, the start of that and the weren't as clear, and it wasn't the same kind of levels and the same clear commitment of atrocities as what happened during World War II. The next issue was you have these 4 different countries with their 4 different legal systems and 4 different senses of justice. So for the Soviets and Stalin, for him it was just, let's just kill everyone. Not exactly, you know, this is his view is much more punitive about let's punish the people, let's use the death penalty. And while the death penalty was given out, I'm sure Americans and French and English were fine with that. It wasn't that widely used. They didn't kill, hundreds or thousands of people, as may have what happened if the Soviets had been running it. But they knew they had to have this trial, which is going to mix the common law systems of America and England with the civil law systems in France and the Soviet Union. There was no kind of clear pre-existing laws. They kind of had to develop the law as the court was going on, based on precedents which had occurred before. But it meant that they had to kind of build this court and build the laws in which they were trying, and then use that to try the leading figures. So the Nuremberg trials were actually a whole set of trials, but the most famous one was this trial of about 12 or so the most senior Nazis. Some famous people here, like Hermann Goering, who was the head of, sitting here at the front, in the front row at the very left, head of the Luftwaffe, sitting next to Rudolf Hess, who had some job, I think, as heading the Gestapo. I'm not quite sure what he did, but these were all kind of very quite senior figures. And a number of these people in this trial faced the death penalty. Not all of them, but many of them. And so the whole kind of point of the Nuremberg trials was this idea that justice needed to be given in a way that wouldn't have this happen again. So we're not going to look at detail at the opening speech here, but it's important to read the opening speech, and you are going to do that for an exercise, to look at what their main kind of ambitions were. Their ambitions were that this kind of injustice could not be repeated. So you see the last sentence here, that these are actions so devastating that civilization cannot tolerate, they're being ignored because it cannot survive, they're being repeated. And a bit of this is about that kind of ghost of World War I and how that World War I happened again in World War II, because there was no trial. Also, that you need to kind of attack the people, you need to kind of put on trial the people at the top and give them sanctions as well. So here it says that in the second quote, it must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. But these are the people we need to look at, this kind of command responsibility, and put these people on trial. So this is from the leading prosecutor, Judge Jackson, who was Justice Jackson, who was an American lawyer who led this opening speech. And these trials were also going on at the same time in Tokyo. They were a bit different because Tokyo just declared war on, they declared war on England as well, but it was mainly England and Britain who were involved in the the battle over the Pacific. And there weren't as many senior Japanese figures put on trial. I think about 15 or 20 of them, which are pictured in this one trial, which is, still based on Nuremberg and still similar in many ways, but also not as famous and smaller. Now, what these trials were trying to do is enforce this idea of individual criminal responsibility. The idea that when these things happen, which are so terrible and so heinous, that the people who created them, the people who made them happen, need to face individual criminal responsibility. Individual, meaning that we focus on the people, that it should be a person and not an army or a state. It's criminal, which means that you get punished. There are sanctions. You go to jail, or in this case, a death penalty, which wouldn't happen now. And it's got to be based on responsibility. Who was responsible for causing this? And they should be the one that faces trials. And those responsible should be the leaders. They are responsible for the conflict. We're not talking about the soldiers, but the leaders. And so it means that individual criminal responsibility is one of the key concepts which made this international criminal law powerful, because it meant that if you break the international criminal law, a person will go to jail because they broke that law. Also, it meant there was an end to this idea of immunity and impunity. Immunity being safe from, and impunity being safe from punishment for the worst crimes. So previously, you could do terrible, terrible things, but if you're head of a state, you're immune. So all previous genocides were not punished at all. And they weren't technically genocides, but all previous mass killings of people weren't punished at all. But still, and this is the last slide, still there were questions and criticisms of these trials. They were talked about as winners' trials, that you're just trying these people because you won it. Now, if you lost, your people will be tried. And this is for things like, say, the firebombing of cities, of Japanese and German cities. We had tens, if not hundreds of thousands of innocent civilians burned to death because airplanes dropped incendiary bombs to set the whole city on fire. There's also a sense that they were tried for laws which didn't quite exist at the time. They kind of invented laws, like later on genocide gets invented. They kind of defined the crime. Not that they were tried for genocide, but things like that, or crimes against humanity, which didn't exist before, but these laws were adapted to try the people, which kind of technically weren't crimes at the time. But still there were, you could argue they were customary laws, it's unclear, but people sort of talk about this, that the laws that they were being tried were kind of not as clear as we think they are. There's also the whole debate which existed for a long time about people saying, well, it's just following orders. So the wardens and guards at the death camps, the extermination camps of the Jews, they said we shouldn't be punished because we're just following orders. We had to follow orders. So this has been a debate which has gone on for quite a while about what's your responsibility and culpability. Were you just following orders, or were you part of the system? Okay. But the thing is, the legacy of this is it led towards these 4 crimes, which are the international crimes mentioned before. What was then called crimes against peace, but now called crimes of aggression. Crimes against humanity, which has been around for 150 years or so. And then war crimes, which are crimes that occur, crimes committed by soldiers, most commonly on civilians. And then we now have genocide. And genocide is a kind of a category of crime against humanity. But the thing is that at these trials, we end up getting these kind of 4 groups of laws: genocide, crimes against humanity, war crimes, and crimes of aggression, being the kind of like the fundamental or the more important laws in terms of international criminal law. Okay, and I'll stop that there.